Good evening. I want to thank you for the opportunity to be here and speak to you and kind of describe what it is that makes me a candidate here. My name is Dennis Morris, and I'm the district judge. I was elected in 2010 in the first judicial race that had been held in Carter County in over 32 years. I was born in Waurika. I grew up in Lawton and Duncan, graduated high school in Duncan, went to college at Austin College in Sherman, Texas, graduated in 4 years. I've been accepted to the University of Texas Law School, but I came home, found a summer job in the oil industry. It was too good to turn down, and so I stayed with that for 6 years and worked in various parts of the oil industry and learned a lot of things, got a lot of good experience. And things kind of slowed down as they seem to do in the oil business. I decided to go back to law school, but I made the right move and I didn't go back to Texas. And I stayed in Oklahoma and went to the University of Oklahoma Law School and graduated in 3 years and started practicing law in 1990. I've been practicing law for 24 years. Started out in Duncan. I was from Duncan, gone to high school there, knew people there, went to work for a small firm there, worked there for 3 years. Then I went to Lawton and worked for 4 years in a little larger firm doing a wide range of civil and commercial litigation. After that, I moved on and came to Ardmore because I wanted to be here, came here in 1997. I spent a little time in the district attorney's office over in Jefferson County, and also when Mitch Sperry was elected, I worked as the assistant district attorney down in Love County because he needed help and they were strapped, and I was one willing to go in and help him, and I did that until they could get the office on their feet, and then I moved on back into my private practice. In the 24 years that I've done in private practice, I've done all types of cases. I've represented, I've done defense work, I've done plaintiff's work, been the municipal attorney for a lot of different small towns. I'm happy to say that I never had any of them sued while I was there. I kept them out of trouble, which in some small towns is a big feat. I've had a lot of clients over the years. You can ask around if you've ever, if you know any of my clients. I've always taken care of my clients. And I learned when taking care of these clients what they expected from the legal system, and that's kind of what I try to offer as a judge. I have been the judge for 4 years, and during that time I've learned a lot of different things, and I continue to learn things on a daily basis. I treat people with respect and courtesy until such time as they disprove their need or their right to have that, and at that point in time I will enforce the rules when I'm required to. I don't want to, but if it's necessary, I will do that. I'm fair, I'm impartial, I treat all people the same regardless of their position in the community, and I want to continue to be able to do that for the citizens of Carter County. I have no special interest. I know a wide range of people. I was fortunate when I grew up that my dad had his own business. He had a body shop, and I grew up working with him in the body shop, and I knew people from all walks of life. And because of that, I learned how to treat people. And that's what I think that I do, especially as the district judge, and I want to continue to do that. Thank you.
Countdown? I'm ready. All right. First off, I'd like to say thanks for having me here tonight. I always enjoy the opportunity to meet new people and get out and tell people why I'm running for district judge and what motivates me to become the next district judge here in the 20th district. A little bit about myself. I moved to Ardmore when I was about 1 year old. Lived here pretty much my entire life through school. Graduated from Ardmore High School in 2000. Then I went to undergrad at Oklahoma State University, graduated there, then went on to law school at OU. After 3 years of law school at OU, graduated and decided that I wanted to see what else was out there. I've been in Oklahoma my whole life and wanted to see what else was out there. So I moved to Kansas City, got a job at a small downtown firm in Kansas City, Missouri, And so I moved up there after graduating law school. I sat and passed the Missouri bar exam, and then a little bit later sat and passed the Kansas bar exam. So I'm licensed in both Missouri and Kansas. And while at that firm, we did primarily personal injury, a little bit of divorce work, and then I really loved criminal law, so I asked my boss if I could kind of branch out and start taking on some criminal clients, which she allowed me to do. So I did a little bit of criminal law on the defense side up in Kansas City. After about a year, I decided that the big town wasn't really for me. I missed Oklahoma and I missed home, so I wanted to come back to Ardmore, which is what I did in early 2010. I came back to Ardmore, interned at the DA's office during the summer, and in the fall of 2010 I sat and passed the Oklahoma bar exam, and pretty much immediately upon passing that bar exam, Craig Ladd, who's the district attorney now, offered me a position, and I've been at the DA's office for the past 4 years, and I've really enjoyed my time there. Just kind of on a side note, 2010 was not only a great year for me professionally, but it was also a great year personally. That's when I met my wife, Janine, who's here tonight with me. When I met her, she had 2 little girls. So I have 2 stepdaughters that are 8 and 6, Presley and Lola. And then not too long ago, we had a little son named Cameron, who's 15 months old. So that's just a little side note about my personal life, my family. Back to the job. In 2010, like I said, I got hired on at the DA's office, and because of my desire to handle criminal cases, Mr. Ladd appointed me to strictly the criminal division. So in Ardmore, I handled pretty much the whole gamut. Felony, misdemeanors, anywhere from a trespassing case one day to a DUI. The next day I may be making a plea recommendation on a burglary case or an aggravated assault and battery. Also, I've had a jury trial on a rape case and second-degree murder case. So handled, like I said, the entire range over here in Carter County. Man, time passes fast. In 2012, I had an opportunity to be promoted, to move over to Marshall County, where I had an opportunity to oversee my own office. I've been there since January of 2012. It's a single attorney office, so I handle all the caseload, all the felonies, all the misdemeanors. A new aspect that I really enjoy over there is I handle all the juvenile cases too, the delinquents, the deprived. Last year, Marshall County is the second busiest county in the district other than Carter County. And again, it's just one attorney. So we filed a little over 260 felony cases, 450 misdemeanor cases, and I was responsible for handling all those cases. And that's a little bit about me, and we'll speak more about why I want to become district judge in just a minute. Thank you.
Okay, we'll give the first question to Judge Morris. If you could change one thing about the court system, what would it be and why?
Currently, under the state constitution, everyone in here is entitled to a jury trial in a civil matter on any case that is over $1,500. Quite frankly, that is not an effective way to do it. That goes back to the state constitution. When that amount was set, $1,500 was a lot of money. Nowadays, that is not a lot of money. And to use a jury to determine a case more than $1,500 is a waste of jury's time. And jury's time is very, very valuable, and that's one of the things that I do, is I'm very cautious about the jurors, how they're treated, and how their time is used. I believe that, and there's been talk of raising this, but the problem is it has to be a constitutional amendment because it goes back to the Constitution, and we would need to have a constitutional amendment to do it. I believe the amount should be upwards of $10,000, perhaps even more. I know that in federal court, the limits have been changed for the jurisdictional amounts required to be in federal court, and we need to raise that, but it's going to take a constitutional amendment to do it. Part of the reason we need to do that is because, and even though $10,000 is a lot of money to most of us, some parties have an advantage because they have the money and they can afford to push another party into a jury trial when the other party can't afford to. And that party is either forced to settle or they're forced to just give up because they can't afford to use the system as it is currently established and pay for an attorney to try a jury trial, because there's no way to try a pro se jury trial. And I think that that would be a very efficient use. It's one of the reforms that we need to make in the civil side of our court system. Thank you.
Okay. The main thing I would like to change, if I'm your next district judge, is I want to work very hard to get a mental health court established. We really need that, especially here in southern Oklahoma. One of the most recent surveys says Oklahoma ranks second in the nation in mental health illnesses. And additionally, it costs roughly $23,000 a year to house an inmate in the Department of Corrections that has mental health illnesses. If we could create a mental health court, which there are some in Oklahoma. Out of the 77 counties, though, there's only 14 at this time. So we're second in the nation in mental health illnesses, but we only have 14 mental health courts. I think we need to push to get one established here. The cost for an individual that goes through the mental health court system is roughly $5,400 a year. That's a savings of upwards of $1,700, $1,800, I did math, yeah, about $18,000 a year that we could save if we're able to get these people back on their medication, get them back to being themselves and becoming a productive member of society instead of just locking them up and throwing away the key. When I initially started as a district attorney, a lot of people would come to me and the defense attorney would say, well, this guy was suffering from mental illnesses when he did this, and take it easy on him. And I didn't really understand it. I said, oh, that's just an excuse they have. But through some personal things in my life recently, and experiencing that, when an individual is going through a psychosis or having a mental health issue, they are not the same person that they are when they're on their medication and when they have a structured environment to be in to keep them accountable. And so I think one of the first things I would try to work on is getting a mental health court established here in the 20th District.
Go ahead and hold on to the mic. Question number 2. What in your current position makes you the better choice for a judge?
I would say, in one word, the experience. Over the last 4 years, I've tried a number of felony jury trials, I've tried a number of misdemeanor cases, and it doesn't even necessarily go into the ability to try a case, but more importantly, what all leads up to that trial. I've had the experiences of looking over the police reports, figuring out if all the evidence is there, or what else we need. I'll kick it back and say, can you find me X, Y, and Z before I file it? And then once it's filed, the process of trying to resolve the case before it goes to trial. There's a lot that goes into that, and those experiences over the last few years, I think sets me apart from the other candidate and makes me very qualified for this position. That a lot goes into that, because when you're a judge, you may have a plea offer for one guy that commits a burglary for 7 years in the Department of Corrections, and another guy that has very similar facts. His plea recommendation may be 7 years with 6 months in the county jail and a long probation. And if you haven't experienced that, if you haven't experienced the loss of a witness that you had one day and the next day they're gone, or you have a witness that really doesn't want to testify, or a victim that comes up and says, I really don't want to testify, can we get this taken care of? If you don't have those experiences and deal with them on a first-hand basis, if you're sitting there and you're looking at just 2 plea agreements, you may be wondering, what's the difference? Why is one side favoring this person when they're trying to send this person to jail? And I think that real-world trial experience and negotiating and working on these cases every day, day in and day out, makes me an ideal candidate for the district judge position.
I agree with Aaron. The one thing that sets me apart, the one thing that we need here is experience. I have 24 years of experience practicing law. I have 4 years of experience as being the district judge. During those 24 years, I represented a lot of people in a lot of different things, not just criminal cases. I have worked as a prosecutor, like I said, in Jefferson County and Love County. I've survived 2 Red River counties. If anybody's read Red River Prosecutor by Judge Bacon, then you kind of have an idea of what we're dealing with there. In the 20 years of practicing in the private practice, I handled all types of cases. I handled complex civil litigation. I handled personal injury. I handled probate. I handled a lot of property issues because my background in the oil and gas business gave me an insight as to a lot of property issues. I also had worked in the oil field, and right now a lot of the cases that we're having filed in the civil realm of the district court are the oil and gas cases and disputes and various things. Also, I handle all the deprived and all the juvenile. And I represented juvenile and I represented children in deprived child cases for 15 years in my private practice. And the last 8 years, I did that free of charge. I did not charge the court system. And not only did I represent children, I represented parents. I believe that that was my way to give back to the community that I was making my living in. And for 8 years, the last 8 years that I did deprived cases for the court, I did it for free. But it's my experience that makes me the best choice is to continue as district judge. Thank you. Oh, I get the next.
Yes, sir. Okay, question number 3. How could the cost of judicial administration be reduced? Can you give us a specific example of how you have reduced cost in your law practice or in the court?
Thank you. I can. One, let me just say that our budget is set by the administrative office of the court, and we ask and they give us what they want to give us. And since I've been in office, our budget has been reduced by 10% over the last 3 years. So we have had to do more with less, but that's like every other state office, quite frankly. One thing that I did, that when I came in, we had 5 jury terms set each year. That's what Judge Walker had always done. Actually, it had been 6 before, then he cut it to 5. I cut it to 4. That saved quite a lot of cost just to bring in a jury. And with those 4 jury terms each year, we have managed to get every case on the docket taken care of, and I'm very proud of that. Now, I will say that I've had to push and shove and make some people do some things. Mr. May knows that I've pushed him and shoved him in the DA's office on some things and made that happen, but sometimes that's what you have to do. Additionally, when I came into office, well, we didn't have, like I said, I also encourage mediation. In civil cases, if one party asks for mediation, I order mediation, because cases often get settled when they go to mediation. It saves the court system a lot of money. And I want to say that the criminal cases are only part of what we do. The civil cases are every bit as important as are the deprived cases, the deprived child cases, and the delinquent cases. Also, when I came into office, they had just built a new office for Judge Baldwin. Furniture that he had there was absolutely worn out and was kind of shameful to have it in a decent office. So I gave him the furniture that was in Judge Walker's office, and I brought my own furniture in, and then I personally bought other furniture. And I want to say one other thing. I traveled the district as part of my job, and I have never turned in a travel claim for the gas expenses. Though I'm allowed and it's expected, I have never done it. Thank you.
You get 5 extra seconds.
Okay.
Or one big glare.
What? I guess I'd start off by harping back to what I spoke about earlier about the mental health courts. The cost, if we can get that established, it would be a tremendous savings, not only to the court system, but the community as a whole. If we can get them back on their feet, becoming productive members of society so they can pay their fines and costs, and so they can get in gainful employment and pay back to society rather than being a burden and being locked up in the Department of Corrections. With my current position, my ability to, I guess, save expenses is somewhat limited. Again, we have a budget that Mr. Ladd oversees, but just kind of on a direct basis, I've cut out quite a bit of the unnecessary law books and journals that are many volumes that we never use, but they're nice decorations. Well, those things cost hundreds of dollars a year, so I've cut those out, so we no longer get those. Everything's pretty much online that you need, and so that's one of the minor things that I've done. But one thing that I would do if I'm the next district judge is, as Judge Morris spoke about earlier, everybody has a right to have a jury trial. But they also, a lot of people don't know, have a right to waive that jury trial. And as Judge Morris spoke about earlier, juries are expensive. But there's been occasions where individuals have wanted to waive jury trial, and the state's been agreeable, but the judge has not allowed that to happen. In Marshall County alone, it's roughly $2,000 to bring in a set of jurors, and that's to pay them for their mileage to and from the courthouse and their daily per diem for sitting as a juror. There really is no downside to not allowing the defendant to waive a jury trial and to make that decision on the bench, other than not wanting to make those tough decisions and saying no to bring in a jury. It saves time, it saves a lot of money. And as your next district judge, if that is presented to me, I would be more than willing to have what's called a non-jury trial and decide that case from the bench.
Okay, question number 4 deals with victimless crimes. Do you believe there is such a thing as a victimless crime? If so, what offenses would you place in that category?
That's an interesting question. I guess you can, if you do the trickle-down effect, you can say every crime has a victim. At the end of the day, it's the taxpayers that are having to pay to prosecute somebody, or that are, you can find a way, like I said, to kind of attenuate every crime, and there's going to be a victim at the end of the day, if you look at it that way. If you want to view the question as, are there any specific instances where something's illegal but does it harm anybody, I would say yes, there are a few instances. And one of those, I would say, would be those individuals that are suffering from chronic pain, whether it be cancer, back pain, multiple sclerosis, anything of that nature. If their pain medicine is not working appropriately and they decide to smoke marijuana in their own home, technically, is that illegal? Yes. But is there really a victim to that? And again, you can always attenuate it to, well, they're supplying the drug guy that they bought their drugs from, and he may be going off and robbing somebody or something along those lines. So yes, you can attenuate that down, and you can trickle it down and say, yes, there's always a victim to every crime. But just to answer that question, are there specific instances where something is illegal, but is anybody harmed by it? I would say yes. And that's really the one instance I can think of off the top of my head that I view in that manner.
Thank you.
Oh, you haven't done victimless crime, have you?
No.
Oh, okay, it's the same question.
Okay. Would you repeat the question, please?
Yes, sir, I'm sorry, I was in my own world there.
That's okay.
Do you believe there is such a thing as a victimless crime? If so, what offenses would you place in that category?
No, I do not believe there's such a thing as a victimless crime, because crimes all go back to society one way or another, and that's the reason that they're crimes. And the example that Mr. Tabor gave, someone smoking marijuana in their own home, I'm sorry, marijuana is supplied by criminal enterprises, and they cost our society in so many ways. Law enforcement, the jails, the prosecution, the social cost, and not necessarily the act, but of the criminal things that follow it. And no, there is not such a thing as a victimless crime. These laws have been developed over eons. We go back to English common law, And what I tell people all the time is, when you really get down to the basics of the law, our law has common sense, and there is a reason for every law that's on the book.
All right, number 5. What do you think about the growing prison population, and what response should society have to prison overcrowding?
That's one of those questions that I can't answer. That is a legislative issue. I will say this, I do believe that violent criminals need to be in prison. They need to be segregated from the rest of society. But as far as prison overcrowding and what we do, whether we give treatment to drug offenses and non-violent offenders, that is an issue that I cannot discuss. That is an issue that you need to call Pat Ownby and Tommy Harden and Frank Simpson and discuss, and decide what we as taxpayers want to pay to house or not house those people. And that's not an issue that I'm free to discuss. Thank you.
It's a tough issue, and there's really no easy answer to it. I can tell you what happens right now, I'm not a fan of, when somebody gets a 10-year sentence and they're out in 2.5 years, or 5-year sentence and they're out in 6-7 months. But it's a tough issue, and there's really no easy answer to it as far as how to handle the prison overcrowding. I do believe that alternative sentencing methods work. Oversee drug court in Carter County, I oversee drug court in Marshall County. That's one way to minimize prison overcrowding, as well as, like I touched about, mental health. But as far as the offenses, and I agree with Judge Morris, when it's a violent offense, obviously they're not going to be qualified for either one of those options. They need to go to jail, they need to go to the Department of Corrections, they need to be there for a while. But what we do about it, there's really not an easy answer at this time. It is a big problem, but like I said, I'm not a big fan of what's happening right now when people are serving less than half of their sentences. But we need to figure out a way to get that fixed.
Okay, question number 6. Would you favor or oppose a system in which all sentencing decisions were routinely reported in the local newspapers, indexed by the name of the judge? Why or why not?
I would be in favor of that. Transparency, I believe, is always the best choice. Letting people know what's going on and what's taking place, not trying to minimize anything or cover it up. Transparency is always the best issue, or the best route on those issues. So a sentencing schedule, if you would, that would be out in the daily newspaper, indexed by a judge. I would be a big fan of that. It just holds everybody accountable. The one thing I would kind of critique to that, those would be nice to also index whether it was a negotiated plea between the parties or whether it was a blind plea that was handed down directly by the judge. There's a lot that goes into pleas, but letting everybody know what's taking place in the courthouse, I don't see there's any problem with that.
System's already in place. All records are public. Anybody that wants to go look for it can find it. The ODCR and the OSCN, you can find that information. There's Administrative Office of the Courts is also working on a new information system which will make that information much more readily available. And the only cases that we do not allow public access to are the deprived child cases, because we have to protect the children in the long run. I agree with Aaron as to the fact that I believe any reporting should be noted as to whether it is a negotiated plea or a blind plea or a bench trial, because all of those things are relevant. I, as a judge, have to rely on the parties, and they know the facts sometimes that I don't know, and I can only make a good decision when I'm presented with good information. It's kind of like the computer, garbage in, garbage out. If you don't have good information, we can't make a good decision. But again, that information is there. You can find it now, it's a little hard. In the future, it's going to be there. I believe it's kind of a non-issue.
Okay, question number 7. What do you believe are the causes of the high rates of minority incarceration?
That's one of those other questions that's verging on the edge of not being able to answer, because as judges, we cannot take a position that would be something that we might have to address. But I do believe that I can say this. The gang presence in the minority communities is part of the problem. The poverty is certainly part of the problem. And probably to a degree, single-parent families. But that's not the main thing. The cause, to a large degree, is the gangs and the associated crime with those. Further than that, I just really cannot comment. Thank you.
I would agree with Judge Morris that the gangs are pretty bad. I think also the environment that some of these kids are raised in play a big role in why the numbers are what they are. And that's one reason I wanted to run for district judge, is because I want to make a change. I'm from this town. This is where I grew up at, and I love this town. And to see what's going on right now is sad. Young adults are shooting each other. You have 15, 16, 17-year-old kids that are stabbing store clerks. And one thing that I would like to do is be proactive. Get to these kids before it's too late, before they're already in the juvenile system, and then we see them a few years later in the criminal system as an adult. One of the first places I spoke at, I talked about some programs that I'd like to try to get started to get out and talk to these kids, not just be an 8 to 5 judge, but you owe it to your elected, the people that elect you, to get out and be seen and be present. And talked about some programs I'd like to start to get involved in the schools, 4th, 5th grade, go out and speak with these kids, let them know that there's other things out there than these gangs and the violence. And what kind of made me, it kind of startled me, is after I spoke, a lady that is over one of the juvenile and child services said, Mr. Tabor, you don't need to invent these programs. We have these programs here in place. We have these programs that go out to the 5th grade level, that go out to the 6th grade level. But we haven't had a whole lot of involvement from the district court level. And that's one thing that really struck a chord with me. And that's one thing that if I'm your next district judge, that I can promise you that I will get out there, and if a school calls and says, we have these group of kids that really want to speak with you, even though our dockets are crowded and they're full, I'm going to make time to get out there and speak with these kids and try to have a positive impact in their life before it's too late.
Okay, question number 8, the last question. Who are your judicial role models and why?
I guess I would start local and say Judge Card. I grew up with his son. I've known Judge Card for a long time, and he's a very fair and honest and hard-working guy. He's been on the bench for going on 20 some odd years, and he's retiring this year. So locally, I would say Judge Card is a role model of mine. It's amazing when you're in front of him and you think you're there for a DUI or maybe it's a felony case, and Judge Card looks at this guy and says, "You were here about 17 years ago, weren't you?" And the guy's dead right. He's like, "Yeah, I was here. I messed up again. I had a DUI about 15 years ago." And it's amazing that the volume of people he sees, he can still remember a face and remember a name, and he takes it on a personal level. And so it's kind of sad to see him go and retire, but I would say locally Judge Card. On, I guess, a bigger scheme or a national level would probably be Justice Scalia at the Supreme Court level. He's just one of those guys in law school that I always usually agreed on whenever he came down with his opinion, and he was very sharp-witted. He's one of those that he would write an opinion or a dissent. He's famous for his dissents, really. And it's one of those that it'd be interesting. A lot of these law school articles or decisions, they're not that exciting. They take a lot of work to actually read them. But Scalia was very sharp-witted. He still is very sharp-witted. He's been the longest tenured justice on the Supreme Court at this time, and on a national level, I'd probably say Justice Scalia.
Thank you. So I'm down for the judges. Yes. 24 years of practicing, 20 years of practicing law. I appeared in front of over 30 judges and probably 2 or 3 federal judges. And I learned something from every one of them, whether it was good or bad. If I had to name a few, because there's no one person that I could name, if I had to name a few, Justice Winchester of the Oklahoma Supreme Court would be one of them. First case that I ever tried was with him. I was by myself. It was a complicated oil and gas issue, and there was a tall building lawyer from Oklahoma City on the other side, and he allowed me to try my case and then gave me the room to do it, and I appreciated that, and I always remembered that. A few years later, I was involved in a very complicated oil and gas case with him. It had over 20 lawyers, and I saw how he handled those lawyers, and especially how he had to rein them in, because when you have that many lawyers in one thing, it's like herding cats. And I saw him do it, but I saw him do it in a very good way. I've been thankful that Judge Card has been here for the first 4 years of my term, because he's always been my friend. I practiced in front of him since '97. He's always been fair, and he's helped me in my job so far. I do hate to see him go, but we'll work through it. And like I said, I took something from every judge that I've been in front of. And I learned that the main thing that you have to do is be fair and be impartial. Don't try anybody's case for them. You let the parties try their case.
Okay, that's the end of our questions. We'd like to open it up, though, and for any questions that you might have for either one of them.
Oh, may I? Francis had a question, and I'd like to start with that.
Sure.
Please. Francis? Here she is. Francis had a question as to, well, who's who on the scorecard? And I think that's a very valid point. In fact, a lot of these things that I've been going to, we get to start off with that. The district is a 5-county district. It's Carter, Johnston, Love, Marshall, and Murray counties. The district judges go back to statewide. There are 2 district judges in the 5-county district. That was it. Otherwise, they had justices of the peace. Associate district judges came in the 60s with court reform, and each county has an associate district judge. That is what Judge Card is. That is what Judge Roberts has been in Love County, what Judge Duck is in Murray County, what Judge Johnson is in Marshall County, and Judge Migliorino over in Johnston County. The district judges have jurisdiction over all 5 counties. That means we can go anywhere in the 5 counties and we can hold court. I can sign a search warrant for any county in the 5, or any of the counties in the 5-county district. Judge Coppedge can do the same. He's the other district judge. Because Carter County has half the population in the 5-county district, this office, Office 1, serves Carter County. That's my primary duty station. Judge Coppedge has the other 4 counties, having the other half. But we have shared jurisdiction. I went over to Marshall County last spring and tried a jury trial because Judge Coppedge was conflicted out. I just went over and did it. Easy enough. I like going to the other counties because during my practice, I practiced in all the other counties. Now, there's one other judge in the district, and that is Judge Baldwin. Before, it was Judge Tate. They are special judges. Special judges are not elected. They are appointed by the district judge, and they serve at the discretion of the district judge. It's a political appointment, and they can be fired at any time by the district judge. Now, Judge Card has decided not to run. Am I running out of time? Well, this is a different, I don't know that this is kind of...
You're lawyers, you're going to keep going until we tell you to
No,
stop.
anyway, let me just finish this part of it, please.
Yeah.
Judge Card's not running. And so there were 4 people that sought that office. There was Judge Baldwin, Brett Morton, who's still in the race, Tim Burson, and Bob Pinkerton. There was the runoff. The top 2 go to the general. Now, if one of those parties would have gotten a majority, it would have been over and that would have been it. But because no one got a majority, then you now have the primary, or you now have the general election with Judge Baldwin and with Brett Morton. In Love County, if anybody's from Love County, Judge Roberts isn't running, and so so there's 2 candidates there. There's Todd Hicks and Gary Brown, and in Marshall County, Judge Johnson is up for election. He was appointed during this last term when Rich Miller retired, and he has an opponent, Michael Haggerty. So we have 3 associate district judge races out of 5 counties and 1 district judge race in 5 counties.
Like to respond to the question?
Like,
Anything to add to it?
No, he outlined pretty much exactly
Have
what's
any
going
other
on
question-
in
another
the 20th
question?
district.
Yes, ma'am.
Yes.
With the marijuana, legalizing marijuana, were old cases where people got convicted of marijuana, would those be overturned?
That's going to be a legislative issue. That's not something that we have anything to do with. Until the legislature acts on that, there's nothing, that's just it.
Okay, and then what about people, like, you've seen time after time that come before you, and it's basically the same offense. Somewhere along the line, don't you say, enough is enough, this is strike 3, you're out?
We do. We have to follow the law. And whatever the law is in the sentencing, and let me explain part of how that works. Prosecutors have a large role to play in what happens when someone is prosecuted. Say that someone has 3 prior felony convictions and they commit a felony offense. And because of the enhancement rules, that would be a minimum of 20 years to life in prison. But the prosecutor may not think that that's the crime that they committed this time, so they can dismiss the page 2, what's the prior offenses, and they can make a plea agreement, and we have to live with that. Again, that's more, and it's also, that goes back to what I was talking about earlier. Part of what you're asking is a legislative issue, and these repeat offenders and the prison and the population, again, that comes down to tax dollars. And that comes down to what the legislature is willing to do, what we're willing to do as citizens in paying taxes, and that's not a question for me. My job as a district judge is to listen to the facts that are presented in court, apply the law that is to that case, and make a fair and impartial decision. We're not policymakers, and what you're asking is a policy question.
Mr. Tabor, would you like to respond?
We're going to do 2 minutes for each of you on these questions today.
Just to answer your question, I guess the short answer is yes. At some point, you got to say, we've had enough, we've seen you enough, and this is what's going to happen. Either you're going to like it or you're going to take the trial. And as a prosecutor, that's a judgment call that I make on a daily basis, and a lot goes into that. But as Judge Morris was describing, what happens is normally if it's your first time offense, you get what's called an information filed against you. If you have multiple or even 1 prior felony conviction, they file what's called a page 2, which means you've been charged with this on page 1, and on page 2 shows what you've previously been convicted of. And that's how the system works. But yes, if you see the same people over again for the same offenses, at some time you have to say that's enough. Either you're going to take my recommendation, which usually if they're repeat offenders is going to be substantially higher than if it's their first time offense, or you can take the trial and roll the dice and see what the jury has to say. That happened in a case I just tried last docket. It was a second-degree rape case where the victim really did not want to prosecute, and she was embarrassed. She felt guilty for letting this happen to her. So after meeting with her and her family 3 or 4, probably 5 different times, we decided that we'd recommend 10 years in the Department of Corrections, so we could try to avoid her having to go through a hard trial. And the guy turned it down. He took the trial, and he got convicted and got 20 years in the Department of Corrections. So to answer your question, yes, sometimes you just have to say enough's enough. And as a prosecutor, that's the call, the judgment call that I've been making for the last 4 years.
Okay, another question?
I want to respond to that just a minute.
It's a
I agree.
response to a response.
Mr. Tabor, as a prosecutor, that's his job. It's not the court's job. Again, we have to be fair, we have to be impartial, we have to take the facts that are presented to us. We're not we're the referees, and occasionally we get to make the decisions, but we only make the decisions when they're presented to us. What Mr. Tabor was saying is absolutely true. As to the prosecutorial side, the judicial side, it's a different issue. And what you were asking is a policy issue that I can't answer.
We'll give him a chance
Okay,
to
sir, go
rebuttal.
ahead.
Did you
Judge
want?
Morris, this is on arbitration. You spoke in favor of arbitration.
Yes.
Do you have a percentage of cases that are settled in arbitration?
The vast majority of the civil cases get settled at mediation. And arbitration and mediation are two different things. Arbitration is kind of like a bench trial, kind of with the judge. He's going to make a decision. He's an arbitrator. He's going to make a decision. Mediation is where somebody goes in, they talk to one side, they go talk to the other, they tell everybody their weaknesses. I can't recommend lawyers as a judge when parties come in. But I can say that we have 2 retired district judges in this area that are doing mediation. And they do a good job. And the vast majority, and I don't have numbers on it, Luke, but the vast majority of cases that go to mediation get settled. Because lawyers work it out, lawyers understand their case, they tell their clients, and when the clients have a third party, and this goes back to my private practice, when the clients have a third party that's telling them what the lawyer has told them, that look, you either have a case or you don't have a case, then those work out. Yeah, large part of the civil cases that I have get settled. That's the reason we don't have all that many civil jury trials, because they get settled at mediation. Mediation works. It's a time thing that I very, very much appreciate.
So it's probably over 50%.
I would think that it's getting close to 50%. Yeah.
Mr. Tabor, would you like to respond?
This three-strikes are out thing. Okay,
Can we
Here,
get
go
the
ahead.
microphone?
Yes.
Just why don't we go back and forth that way? Go
Okay.
ahead.
This three-strikes are out thing. If they commit a felony to start out with, all right, do the next 2 have to be on the same footing as the first one? Be a third strike, or are there different levels of that?
They don't. There's actually 2 different ways to enhance a felony, and this is kind of getting into the technical aspect of it, but you can do a general enhancement, which means if you have a prior felony, we can enhance what has that prior felony. And then there's also...
What about the felony, though? That's why I'm asking the question. The first felony wasn't really a bad felony. The second felony made it a little worse. The third felony was real, really bad. Or reverse it. The first felony was real, real bad, you let him go. The second felony wasn't so bad, you let him go. Third felony was even less than the other first 2. Does that still count the third strike?
It does, but that would be an opportunity where we could not file a page 2, or file a page 2 and use that kind of to our advantage in plea negotiations. Say, I understand this, it's a felony, so it's probably going to be a serious offense, but say it's not a serious, that serious of a felony. Say with your priors, this is enhanced in the minimum punishment, maybe 6 years, minimum punishment, maybe 20 years. But if we could work out a plea agreement, I'll dismiss the page 2 and you can settle it that way. So sometimes you can add page 2 or you file a page 2 and use that through plea negotiations. But the whole third strike and you're out, it doesn't really quite play out like that in the courtrooms. I don't know if that's exactly an answer to your question or not.
First thing, Oklahoma doesn't have a 3-strike and you're out rule. We haven't attached the procedure. And that is a prosecutorial issue. that is not an issue to the court. I can't offer an opinion on that because, again, I have to take each case as a judge. I have to be fair and impartial and take each case on its face. And that's where we as judges rely on the parties. We rely on prosecutors to do their job, defense attorneys to do their job, everybody to do their job. And all we can do is do the case that is presented to us. And prosecutorial discretion carries far and wide, and we don't have 3 strikes. But again, what you're asking is a policy and a prosecutorial issue.
Okay, other question?
Wendell?
In each one of your cases where you currently are, if the state of Oklahoma did for some reason decide to legalize marijuana, what percentage of your caseload would that affect in each one of your areas? Would that decrease your case? Well, would that procedure decrease your caseload?
Well, that's a hypothetical as far as what it would do. I don't know what the number of marijuana cases are, in this court. I've never counted those up, so I can't say. And anything beyond that would be a hypothetical, but again, as a judge, I cannot give you an opinion.
I'll stay with the marijuana thing.
Let's
Hold on, he gets an answer.
Yeah, let's go ahead and let Mr. Tabor answer.
I agree. It's a hypothetical, but to answer your question, it would reduce the number of cases significantly. Probably the most filed misdemeanor charges of possession of marijuana, whether that be here in Carter County or Marshall County, where I'm practicing now. So I agree. It's a hypothetical, but just to answer your question, would that affect the caseload? Yes, it would reduce the number of cases filed. Probably, I'm not going to put a percentage on it, but pretty heavily, because possession of marijuana, other that and the DUI, are by far the 2 most filed misdemeanor cases.
In the example you all used, both of you, would be somebody was sitting in their house, their back hurt, and the pain pill stopped, so they started smoking marijuana, all right? Number one, how did they find out about it? And number two, isn't actually the person who is selling the drug the real bad guy, not the individual who's trying to cure the pain?
I guess I'll answer that first, since I'm the one that kind of brought that up. The question that related back to was there a victimless crime?
Yeah.
And that was just an example that I thought of, would there be a victimless crime? And I think that sort of is. But how would you find out about it? That's a tough answer to question. Tough question to answer. I didn't mean to get us on this trail of marijuana or anything of that nature, but the question really was, is there a victimless crime? It was just kind of a hypothetical. But as far as how they found out about it, I don't know. And I would agree that.
Okay, who's the victim? Who's the victim who was not the victim in that situation?
I would say that's why I use that as an example of what I believe there really wouldn't be a victimless crime if you were sitting at your house. But again, you can always trickle that down and say, well, the guy that delivered the drugs, if the guy's eventually caught, the taxpayers have to spend the money to prosecute it. So I didn't mean to open up this long discussion, but that was just one example I had of a possible victimless crime.
Okay, so go ahead.
This may not be relative, but we all hear about Colorado, and how marijuana is legal, and I guess all faces of marijuana are legal. What about the people that are incarcerated for marijuana?
That's the question that the lady back here asked, that I said I can't answer.
That'd be great.
No. They still are incarcerated, aren't they, Judge?
Yes, unless the legislature changes
So
the
the
law.
legislature will have to change that.
No, that's what
They
I
would
said.
have to
It's a
make it
legislative issue that I
retroactive.
can't answer.
Yeah.
Well, I'd like to ask you a question. Since you say it's not a victimless crime, who is the victim? If I'm growing a plant at my house and I'm smoking it at my house, who is the victim?
Society, because of the costs that are associated. And
What costs are associated with that?
You're asking a legislative issue. My job as judge is to enforce the law that is currently on the books. And I can't express, you're asking a personal opinion that I can't express. No, you are. Believe me. You are. I can't, no,
I mean,
sir.
from a legal standpoint, who's the victim in that?
The legislature has made it a crime. It's my job as the judge to enforce that law. And until they change it, that's all that can be done.
One more question for Francis, and then we'll wind it down.
What are the options on alternative punishments rather than jail time? I mean,
We have drug court. We have drug court. People that have committed offenses, second time, they can get into drug court, and they're monitored closely. They're drug tested regularly. They understand that it's usually the situation that if they've, their original plea agreement was that they might do 2 years in prison, but the maximum is 10. They'll get 10 years. They're going to plead to a sentence of 10 years, but they're going to go to drug court. If they successfully completed it, it's dismissed, and so they don't have to do the time. And that's the hammer hanging over their head.
I wasn't thinking of just drugs. I was thinking, I've seen where the Arizona sheriff or judge had some sort of a public
Shaming?
shaming, yeah.
Well,
something of that sort.
We don't have that here.
Not allowed?
No, and again, I have to operate within the law. Want to do things like that, we've got to go and talk to the legislators about coming up with some of those ideas. And a lot of these alternative punishment issues come down to funding. Everything in life is a function of money. It all depends on how much taxes we want to pay, how much services we want. And that was what Mr. Tabor was talking about, the mental health court. Until we get the services that we can order people to, mental health court, that's getting the cart before the horse, because on average right now, we have less than 50 mental health cases that come before the court each year. We handle them on an as-needed basis. We have a hearing within 48 hours. And go talk to the legislator. Pat Ownby is high behind that issue. They had a good article in the paper several months ago about that. But you need to talk to Pat Ownby and Frank Simpson about those issues, and Tommy. And if we all want to pay for it, we can have it. I want to thank everybody for being here. Thank you.
Just to touch about some of the alternative sentencings. One thing we have in place in Marshall County is community sentencing. It's a program that's put on by DOC. They actually assist in the cost of outpatient counseling, drug testing, things of that nature. It's a deterrent to minimize the cost, so they're not just housed in DOC, but actually DOC helps offset and pays money for us to supervise them and keep a close eye on them while they're in the community. Secondly, as Judge Morris talked about, we have a drug court, which has been pretty successful over the last few years. And then just to kind of clarify on the mental health, Judge Morris is right that we have about 50 or so mental health cases every year. But those cases are not what I'm discussing about regarding a mental health court. Those are cases when somebody is having a psychotic episode or psychosis, and they haven't committed any crimes, but they are harmed to themselves, or they could potentially be harmed to someone else. So they are what's called emergency EOD, the emergency order of detention, and they're sent to a facility for usually about 72 hours to try to get them stable again. The mental health court that I was discussing is for those people that have committed crimes. They've been charged with felonies, but when those were committed, they were going through a mental illness. And this is a program similar to drug court where you can keep a close eye on them, get them some outpatient counseling, get them on their medication, and monitor them and supervise them. And similar to drug court, we'd have some sentencing alternatives where if they don't complete it, it would be a little bit stiffer than if they would just take the initial plea. Lastly, I agree that there are some funding issues, but for over the past year and a half, I've served on the Board of Directors for Mental Health Services of Southern Oklahoma, and I know that in this area we have some very, I guess, lucrative donors that are very interested in mental health courts. So instead of just saying it's a funding issue, if we have people at the top that want to think outside the box and could approach maybe these individuals and ask for a grant to help them get the mental health court started, and then talk with the state and see if we can work together. I think there's other issues and other ways to get one of those in place, other than saying it's just a funding issue. We can't do it right now.
All right, how about closing remarks?
Go ahead. I just want to say thank you for your time. It's been an honor to get up here and talk to you guys and kind of tell you what all I'm about. When I decided I was going to run for district judge, there were a lot of things that I had to think about. And one of the biggest issues that came up was my age, and you're too young to run for district judge. But what I caution people when I get out and speak with them is not to mix up youth with inexperience. You can be young and you can be youthful and you can have experience and the qualifications to be the next district judge, which I believe I do. Judge Miller, who recently resigned as a district judge, or as an associate district judge in Marshall County, got on the bench when he was 32 years old and was on the bench for almost, actually a little over 25 years. Judge Card, who I think me and Judge Morris would both agree is a very fine associate district judge, got on the bench when he was 35, and he's served this community for well over 20 some odd years. I believe that with my experience and my dedication and my hard work, that I would be a great district judge for this county, and that's why I've decided to run. I really want to make this a better place, and I think I can do that. And I just ask for your support on November 4th.
It takes experience to do this job. We talked about Judge Card. Judge Card had practiced laws for 11 years before he went on the bench. He had been in the prosecutor's office and also been in private practice for 6 years. I had someone tell me the other day that they don't believe that anybody that hadn't been in private practice should be on the bench, because if you haven't had a client, you don't know what it is to deal with people, and we're in the people business. Again, I've had 20 years of practicing law in all types of different cases, both prosecuting, defending, doing plaintiff's work, doing defense work. I've represented all sorts of people, and I've learned what people expect from the law and from the courts. I also worked as a municipal judge, the alternate municipal judge, for about 10 years for the city of Ardmore. And somebody gave me a book early on that said that that's where most people in our society get their exposure to our court system. And I was always very cautious with how I treated people, because it was one-on-one in there, and I believe that everybody deserves to be treated fairly and impartially. And that's what I do. I treat people with respect. I've never had an issue with a client in the courtroom. I've had a few issues with a few lawyers when they get out of hand. And in fact, one time, I always have this habit of talking to jurors after the jury trials. We had one last year, prosecutor, it was a criminal case, and after the fact, went in and talked to the jurors, and the first question was, well, how do you put up with either one of those guys? Well, they were both doing their job, and that's what I explained to them. Oftentimes, you have to be the referee. You have to control the situation, and you have to put up with these huge, larger-than-life personalities of lawyers. And my experience allows me to do that. My vast experience of practicing law for 20-plus years in all types of cases makes me the candidate, makes me the person for this job. I want to thank everyone for your attendance tonight, and I appreciate it very much. Thank you.